All right, license and law. Sounds good. Oh yes, the rules of the Ohio Real Estate Commission. Do that. And I will make my screen. All right, let's jump right in. So what type of property is encompassed by Ohio's broker lien law? Is that A, four-family apartment complex, B, vacant property zoned residential, C, single-family residence, D, commercial property? So what type of property is encompassed by Ohio's broker lien law? This is a tough one. I'm actually not sure what this one is. What is encompassed by Ohio's broker lien law? I'm actually just right across the way from our broker, so I should ask him. All right, A, let's check it. Okay, so good. It is commercial property. So Ohio broker lien law covers commercial property only. A broker may file a lien for unpaid commission against commercial property, but not against residential property. All right, good to know. That's a tough one. Hopefully you won't see this on your test, as it has to do with commercial property, but you never know. We'll trick you. So it looks like, so again, Ohio broker lien law covers commercial property only. A broker may file a lien for unpaid commission against commercial property, but not against residential property. Okay. How many hours of continuing education are required by an Ohio licensee over a 3-year reporting period? Is that A, 20 hours, B, 35 hours, C, 26 hours, or D, 30 hours? D? And D is correct. Good job. So a licensee is required to submit 30 hours of continuing education every 3 years after the initial issue date on or before his or her next birthday. Yes. So it's the continuing education over the 3 years is going to be 30 hours. But then the first year, which is that post licensure, and it's a specific course, that's the 20-hour. Good job. Next question. If given the choice, what type of listing agreement would a seller probably prefer? Is that A, exclusive agency agreement, B, exclusive right to sell, C, open listing, D, net listing? So if given the choice, what type of listing agreement would a seller probably prefer? Go ahead and copy paste the question in the chat. All right. The open listing. All right, that was a good guess for sure. But it is the exclusive agency agreement. And an exclusive right guarantees a broker commission no matter who finds the buyer, even if the seller finds the buyer. An exclusive agency agreement states that if the seller finds the buyer, then the seller saves the commission. So this is actually not even an option in Ohio, but exclusive agency agreement is when you work with a agent, but the seller then finds the buyer for their home, so they don't have to pay the agent if they find the buyer. And we actually don't practice that in Ohio, so crazy how they put it out here. Definitely knowing the difference, but the most common you'll see is going to be the open listing exclusive right to sell. And the one that Ohio mainly uses, I've actually never seen any other one besides the exclusive right to sell. All right, next question. The rate of commission for residential properties is set by the A, Ohio Real Estate Board, B, Multiple Listing Group, C, Ohio Real Estate Commission, D, broker and the principal. So the rate of commission for residential properties is set by the which group? Sorry, I didn't choose an answer. This automatically shows that for me. The rate of commission for residential properties is set by the feel like they're trying to trick you, so I already guess I would say broker and the principal. All right, so that is set by the broker and the principal. The rate of commission for residential and commercial sales is not set by law, but is completely negotiable between the broker and the seller, which is the principal. All right, next question. A broker loses her license and there is no licensed broker to take over the broker's business. In this case, A, the sales agent may take over the listing. B, the probate court must approve the appointment of the ancillary trustee. C, an ancillary trustee may be appointed by the superintendent to conclude the broker's business. Or D, the sales agent may take over only those listings that are in contract. This is a tough one. A broker loses her license and there is no licensed broker to take over the broker's business. In this case, what happened? B? Uh, All right, that was a good guess. So it is still it involves the ancillary trustee, but it is C. So the probate must approve the appointment of the trustee only in the event of death of a broker. Otherwise, the superintendent has the power to appoint an ancillary trustee. A sales agent would be allowed to take over the broker's listings only if appointed by the trustee. All right. So that was a really good guess. They tricked you by um, stating that they lost their license, but in the death of a broker, that's when probate comes is involved. So whenever you think of probate, sorry, whenever you think of probate, the just unfortunately think of death when it comes to real estate, when the probate court becomes involved. Yeah, good job. What lien automatically attaches to a commercial property to secure a broker's commission? Is that A, broker lien, B, attachment lien, C, mechanics lien, or D, judgment lien? So what lien automatically attaches to a commercial property to secure a broker's commission? Let me see. C? All right. Again, another good guess. I didn't even know there was a broker lien out there. So under the broker lien law, a broker can attach a lien to a commercial property only. When lien automatically attaches to a commercial property to secure a broker's commission. Under the broker lien law, a broker can attach a lien to a commercial property only. Okay, so it looks like we are getting a lot of the commercial questions here. So in this case, whatever you, these liens don't account for residential, so you probably won't see them on the test. Oh my gosh, I didn't know this either. These are tough questions and probably aren't even in your books. These may just be like encompassed with um, the broker, the broker questions as well. So don't fret. You guys are just going to know even more material. Under Ohio law, a non-licensed employee of a property manager may A, negotiate a lease between the landlord and a potential tenant, B, explain the difference between a periodic tenancy and a month-to-month tenancy. C, prepare the lease for a landlord tenant. Or D, accept payments of pre-negotiated rent from a tenant each month. So under Ohio law, a non-licensed employee of a property manager may do what? D. All right, good job. So a non-licensed individual working for a property manager may accept rent, show the property, and have a tenant sign a pre-prepared lease agreement. The unlicensed person is not authorized to prepare a lease, but may offer a signature for pre-prepared leases. Good job. So definitely noting everything that a non-licensed individual working for a property management company can do is accept rent, show the property, and have a tenant sign a pre-prepared lease agreement. Good job. When would a license be considered inactive? A, when the salesperson directs the broker to return the license to the division. B, when the broker dies. C, when the salesperson does not have a transaction within the mandated period of time. Or D, when the salesperson fails to turn in proof of CE, which is continuing education. So when would a license be considered inactive? Good job. So D, actually, when the person starts to return. Oh, that was a tricky one. I thought it was D as well. So it is when the salesperson directs the broker to return the license to the division. So when the salesperson fails to turn in proof of CE, they are suspended. I completely read that wrong too. So inactive is when a salesperson wants their license to go inactive. They may be taking like a break from being an agent and they'll become active again when they're ready. And then if they fail to do the requirements that the state requires, like those classes or renewing it on your birthday, then you're suspended. That was tricky on it. Next one. Who administers the real estate license law? Is it A, the police, B, real estate commission, C, Department of Commerce, D, Division of Real Estate? So who administers the real estate license law? I do not remember this one either. Gosh, I feel like I need a refresher. I forget what each of these guys do. The Division of Real Estate, Department of Commerce, Real Estate Commission. Oh, we got D. Correct. Good job, guys. So the Division of Real Estate administers the license law. Cool. Yeah, definitely just knowing what each one does and where they're ranked and kind of their responsibilities is going to be helpful for the exam. Good job. A licensed property manager is negotiating a lease on behalf of a commercial landlord. The property has to be rented. The property to be rented is retail space in a soon to open mall. What type of lease would you expect the property manager to negotiate? Was that A, percentage lease, B, land lease, C, net lease, D, gross lease? Question. All right, A. And that was correct. It would be a percentage lease. Is usually used in retail establishments with the rent based upon a percentage of the sales that the tenant makes each month. A gross lease is usually found in apartment settings, and a net lease is usually found in heavy industrial settings with the tenant paying rent plus taxes, utilities, and insurance. A land lease usually a land lease usually involves farmland. All right, good job, guys. Definitely noting what each of those does, and an example is going to be helpful for the exam. Okay, so under Ohio law, every listing agency agreement must have a mandatory extension clause, B, the company policy for brokerage and dual agency, C, the diversity in housing logo, D, a statement defining the practice known as blockbusting and stating that it is illegal. So under Ohio law, every listing agency agreement must have what? All right, we got D and C. About first is D. So this one is the diversity housing logo is definitely similar to like fair housing. They just kind of switched up the verbiage. And that was where for them to trick you. And then blockbusting is on the listing agency agreement, whereas diversity or fair housing is on the agency. So each written agency agreement shall contain an expiration date and a statement that is illegal to refuse to sell or rent property because of the person's race, color, etc. A statement about blockbusting may also be contained in the listing. So the diversity logo, which is also kind of touching on fair housing logo, this was a poorly answers because it could be both C and D. They just used a different term for fair housing. But just know when it says listing agency agreement, blockbusting must be on it. So if a broker dies and there are no other brokers in the firm, what is true? Okay. So the Ohio Real Estate Commission may appoint an ancillary trustee. The superintendent may appoint an ancillary trustee with the approval of the probate court. Any salesperson associated with the firm may take over the deceased broker's listing. The Department of Commerce will appoint an ancillary trustee. Copy and paste question. Good job. That is correct. Good work. So probate court involving that work. All right. So the commission shall suspend for a minimum of 2 months or revoke the license of a broker or sales agent found guilty of a first fair housing violation offense, B, third fair housing violation offense, C, second fair housing violation offense, D, fourth fair housing violation offense. Oh, this is a tough one. The commission shall suspend for a minimum of 2 months or revoke the license of any broker or sales agent found guilty of what? All right. That was tough. So it's a second fair housing violation offense. So in this one, these are tough to remember, but the commission shall suspend for a minimum of 2 months or revoke the license of any broker or sales agent found guilty of a second fair housing violation offense. So at minimum, when it comes to their second, the commission must come into play. These are hard. A sales agent states in his advertisements that he will provide a free room addition to anyone who buys one of his listings. What is true? A, this is legal as long as the inducement is disclosed between the buyer and seller. B, this is unethical as the sales agent is not allowed to offer an improvement in real property as an inducement. C, this is legal as long as this is noted on the sales contract. Or D, this is unethical. A sales agent may not offer anything as an inducement. All right. Right. Yeah. Okay, we got two C's maybe. I think it is C as well. All right, good job, guys. So yes, it is C. So as long as it becomes legal, as long as we note it on the sales contract, and if both parties sign the sales contract and it's disclosed to buyer and seller, then it is legal. Good job. What would you expect an Ohio property manager to do? A, prepare a land contract in case the landlord wanted to sell the property to a tenant. B, prepare lease agreements for tenants to sign. C, convert the apartments into condominiums for the landlord. Or D, initiate actions for the recovery of rent. So what would you expect an Ohio property manager to do? And that's correct. It's going to be D, initiate actions for the recovery of rent. The property manager may initiate action for the recovery of rent on behalf of the landlord. The other actions involve the unauthorized practice of law. So we can't create contracts. The contracts are created for us and we use those. Good job. Who approves the appointment of the ancillary trustee when a broker has died? Touch without this question. Is that A, Department of Commerce, C, probate court, or B, probate court, C, commission, D, division? Gosh, we're going to be a pro at this question. Good job. It is the probate court. When must a broker record a written release or satisfaction of the broker lien in the county recorder's office in which the lien was recorded? Is that A, within 90 days after the owner satisfies the claim? B, within 15 days after the owner satisfies the claim? C, the owner must file the release of a lien after the claim has been satisfied? D, within 10 days after the owner satisfies the claim? Yeah, that was a hard, that's a hard question. I have no clue. All right, good job. It is D, within 10 days after the owner satisfies the claim. States that release or satisfaction of broker lien must be recorded within 10 days after the claim is satisfied. Good to know. A lot of broker questions on here. So these hopefully won't be on your test. I don't believe that they are. After recording an affidavit of lien with the recorder's office, the broker shall provide a copy of the lien affidavit where a contract for sale or other conveyance of the lien property has been entered into to the A, owner of the lien property and the prospective transferee. B, prospect of the transferee. C, owner of the lien property. D, superintendent. These are tough questions. Mm. C. All right, that was a good guess. So the owner of the lien property is involved, but so is the prospective transferee. So when a contract for sale or other conveyance of lien property has been entered into the affidavit after being recorded shall be served either by personal delivery or certified mail upon the property owner and if known upon the prospective transferee. It's hard. Gosh, a lot of these seem like they're Ohio broker questions. So John, a real estate agent, has been found guilty of violating the Federal Fair Housing Act for the third time. what most likely will occur? A, John's license will be suspended for 2 months. B, the commission will revoke John's license. C, John will be fined a minimum of $2,500. D, the commission will suspend John's license. So this is his third federal fair housing violation. All right. Got 2D. All right, and that is B. Good job. So if there is John's first offense, when the commission might suspend John's license. If it were a second, then the commission would suspend him for 2 months or permanently revoke John's license. But since it's his third, the commission must revoke the license permanently. There's no minimum fine that the commission must levy against any sales agent or broker. All right. Good job, guys. So this one is going to be when it's your third offense, your license is revoked. A buyer makes an offer on a property. The seller issues a counteroffer, which the buyer signed and the selling agent delivered to the listing agent. The buyer passes a for sale by owner, which is a FSBO, and likes it better. He makes an offer to the for sale by owner and the seller accepts. Which of the following is true? Both contracts are valid, only the first contract is valid, neither contract is enforceable, or the contract on the first house is not enforceable. Ooh, tough. That's kind of a tricky question. Both contracts are valid is correct. Both contracts are valid. The buyer has purchased 2 properties. Both contracts are valid. Good job. All right. Okay, well, that was a hard one. What should our next topic be? Glad we did that one. Any topic that you guys want to go over, feel free to just pop it in the chat, say it out loud, whatever works.
How about the property condition and disclosures?
Okay, sounds good. Property condition and disclosures. Cool. Yeah, I don't think we've done that in a while. All right. When an owner of property fenced their yard, they located the fence where they believe the property boundaries were located. What action should a prospective buyer take in order to ensure the fence does not encroach on neighbor's property? Is that A, have a title search done for the public records and an abstract of title prepared? B, rely on disclosures made in a seller's property condition disclosure statement? C, have a boundary survey done by a licensed registered land surveyor? Or D, personally contact all owners of property adjacent to the property being purchased? Good job. Yeah, you would need a licensed surveyor is trained and authorized to locate property boundaries and identify any possible encroachment. Good job. I definitely did have that one on my exam or something similar. So the land surveyor, a licensed registered land surveyor handles encroachment. All right. George, the owner of a single family home, has given his neighbor John the right to access John's property by using George's driveway since John has no public road access to his property. This right is recorded in the public record. When selling his property, George will be required to disclose this fact because A, John has a deed restriction which affects George's ownership. B, John holds a defeasible fee estate in George's property. C, John has an estate at will with regard to use of the driveway. Or D, John has an easement, opportunity, and a dominant tenancy with regard to George's property. Oh, I really like John. Question? All right. Got D, and D is correct. John enjoys an easement opportunity which involves two adjoining properties, one of which benefits and holds a dominant tenancy. John has no ownership or title to the driveway, nor does he enjoy a leasehold interest. Good job. The term red flags used in reference to property condition refers to A, a latent defect not discoverable by ordinary inspection. B, visual signs or indications of a defect in a structure, its major components, or the property itself. C, any off-site issues that may have negative impact on the property's value. D, any mechanical component in a property at or near the end of its economic life. Oh, they all sound like red flags. All right, we like B. And B is correct. Good job. So latent defects are problems not discoverable by ordinary visual inspection. Offsite issues are not related to property condition, even though they may impact value. The fact that there is a mechanical component is near end of its economic life is not a defect. Red flags are readily observable signs or indications of a defect in the structure, its components, or the property itself. So actually my first deal had structure issues. I didn't know it was a red flag at the time. Wish I would have known prior. So yes, definitely structural issues, especially when passing loans. Loans won't be like the loan officer will not give a loan to properties with structural issues if it's a specific type of loan. Like the guidelines for an FHA loan do not. If it's not inhabitable or has structural issues, you will not be able to receive the FHA loan. All right, so a property considered undesirable because of an event that has occurred there, such as a suicide, murder, illegal drug manufacturing, or gang-related activity is classified as A, stigmatized property, a B, uninsurable property, a C, nuisance property, or D, unsellable property. All right, A, a stigmatized property, and that is correct. Good job. Good work. So federal regulations require real estate professionals and property owners to provide a specific disclosure language and forms to purchasers and prospective tenants of single-family housing constructed prior to 1978 regarding the presence of A, lead-based paint, B, radon, C, mold, D, asbestos. All right. Good work, guys. And that is lead-based paint. This will definitely come up in every single one of your deals. If the property is constructed prior to 1978, is definitely a key thing. If you're listing a property, you need to know when it was built because you'll need to include the lead-based paint if it was built prior to 1978. Good job. So in order to ensure that a prospective buyer is provided with information concerning structural, mechanical, and other property conditions so they can make informed decisions, licensee representing sellers should A, have the seller complete a property condition disclosure form to accurately and honestly disclose what they know about the property. B, insist that the seller have the property inspected by qualified professionals before listing it for sale. C, require that only the buyers represented by buyer's agents be shown the property. Or D, complete a property condition disclosure form on behalf of the seller and provide it to prospective buyers. Right. And good job. Yep. So you'll have a seller complete a property disclosure form to accurately and honestly disclose what they are known about the property. Good work. So yes, definitely when you get access to the MLS, once you pass your exam and then you get access to the MLS, anytime you have a listing, in the supplements portion, you will have your sellers fill out the lead-based paint if their house was built prior to 1978 and a property disclosure. You cannot fill this out. Good job. Next, controls on the development of areas designated as wetlands have become the subject of recent regulations because A, wetlands are a major source of flooding in certain areas of the country. B, wetlands are recognized as a natural resource necessary to maintain ecological balance in the environment. C, local governments have the primary responsibility on how wetlands can be developed. Or D, mosquitoes and other disease-carrying insects which breed primarily in wetlands need to be redacted. B, and that's correct. Good job. So wetlands are recognized as natural resource necessary to maintain ecological balance in the environment. In evaluating the property to be insured and the buyer purchasing the property to determine insurability and premium to be charged, insurance companies often use which of the following? Is that A, FICO credit scores of the buyer and seller, B, a home inspection done by the insurance company, C, a clue, which is a comprehension loss underwriting exchange report, or D, a coinsurance clause in the homeowner's policy. All right, we're going to do a clue, and that's correct. So yes, so with insured, just underwriting or it's going to be how it's good to remember it by that. Anything that needs to be insured needs to go through underwriting. A property owner is involved in litigation which could result in judgment affecting title to their property. Because of the time delay between filing a lawsuit and rendering of a final judgment, what action could be taken to protect a claimant's interest? Is that A, have the clerk of courts enter a confession of judgment, B, secure a writ of execution, C, record notice of lis pendens, D, have the property owner execute a waiver of lien. They love throwing in vocab words into not only the question, but also the answers. Yeah, this is a tough one. All right. Is record a notice of lis pendens. So when a suit is filed that affects title to real estate, a special note known as I don't even know if I'm saying this right, which is litigation pending, is recorded to protect the claimant's interest. A writ of execution is issued after a judgment is awarded, and a waiver of liens is used to protect against mechanics lien. A confession of judgment is used to avoid the necessity of court action to enter judgment. It's executed by a debtor. Well, this is a helpful definition of each one. But yeah, that was a tricky question. All right. All of the following are true regarding the National Flood Insurance Program, except A, unless required by a lender as condition of the mortgage loan coverage is not effective until 30 days after the purchase of the policy. B, the program covers loss or damage to personal property caused by a discharge or overflow of water from plumbing, heating, or air conditioning system. C, if the property is located in a designated special flood hazard area, federally related loans require flood insurance. Or D, the program is administered by the Federal Emergency Management Agency. So all of the following are true except. Correct. Good job. keyword accept. All right. So exam category. Is there anyone category that I should hop into next?
So I took the test like a couple weeks ago, and something that I struggled with was zoning and permits, and I
Mhm.
I don't know what I guess
Yeah.
that was like a lot of questions on the test that I had.
Okay. Yeah, so I actually took the exam uh 4 times. So I was like a struggle with each topic each time. But yeah, that was definitely a big factor. I want to say that's land use controls and regulations. Let's see, what would that topic look like?
That's why I thought like maybe that was gonna be it, but there was like no zoning.
Yeah, there wasn't. Crazy. I would think it would be under that too. Hmm. See. And then it's state government. Um, You know what? Let's see. So we can try valuation and market analysis, or we can also uh, go through land use controls and regulations, see if they switch it up, and if they don't, we can always exit.
Or whatever, I'm sorry, whatever she just said that she needed help with,
Oh,
the broker.
broker question. My questions were broker. Oh, see, that's crazy that there's so many broker questions on a salesperson exam. Hmm. Oh, I see. You want the broker relationships agency law. Oh, got it. Okay. Yeah, that's wild that there's so many broker questions on these. Here, yeah, we could pop in and see if the valuation market analysis may have some of those questions about zoning and like, is that like police power and what else is the definitions like, I don't remember. Let's see. Oh, actually, you know what? Let me see if I go here and then launch study vocab and see what those come up. Okay, so it's similar to like these
Yeah,
questions. Okay,
yes. Hmm.
got it. Okay, so we were in the right section. They just weirdly didn't ask us anything. So yeah, we could take another one. Let's try it again. Because yeah, I had a lot of those questions as well. Now that I'm looking at all the definitions. Land use and okay, cool. All right. Okay, cool. Right off the bat, they heard us. A developer wants to develop a subdivision that would include housing, office space, restaurants, and retail stores. Which must the developer get their subdivision approved as? Is that A, plat, B, planned unit development, C, CC and Rs, or D, condominium status? Yeah, these are tough. All right, we got answers all across the board. Okay. Wait, don't know. I can't remember which one. So is there going to be a tiebreaker? Does anyone want to take a stab at it? I have C, B, or A. So I'll choose the middle one. All right, so it is A. So a planned unit development. So any subdivision that will have more than one land use within the development must be approved as a planned unit development, which is referred to as a PUDS. Yeah, so what's tricky is they will like spell it out for you sometimes, or they'll use acronyms sometimes, or they'll use like principal instead of client. So definitely just knowing like the AKAs for all of them is will be very helpful. So a plat would be detailed survey map of the subdivision. And then the condominium status is what a developer declares when recording the declarations and bylaws. DC and Rs are the record covenants, conditions, and restrictions imposed on the entire subdivision. So that is kind of similar to like an HOA. This is tricky. I'm glad we're going over this. Okay. A charge against the property owner to cover the proportional cost of street paving is an A, assessment, B, county tax, C, ad valorem tax, D, equitable obligation. So a charge against the property owner to cover the proportional cost of street paving. A, assessment. That is correct. So an ad valorem tax is based on the value of property and the normal tax the property owners pay. And then an assessment is actual charge against the property owner to cover the cost of an improvement made by the municipality, and so like basically the city. And then a county tax should be sales tax. And then equitable obligation would be the owner paying their fair share, which is homeowner association assessment for a new tennis court. Okay. So when you think of equitable obligation, that is involved in like an HOA assessment. And then an actual assessment is when a property owner, so like a residential property, is taxed by the city for an improvement. So laws that regulate the types of activity that may be undertaken in different areas of a community are called A, building codes, B, rights of way, C, zoning ordinances, or D, setback regulation. The laws that regulate the type of activities that may be undertaken in different areas of a community are called what? Zoning ordinances? And that's correct. Good job. So zoning ordinances are set forth general uses for property in various areas of the community. Example, residential, commercial, or industrial. Setbacks require buildings to be specified distance from the front and side property lines. Right of way generally define land of public streets and future expansion of streets. And building codes establish standards for the construction of private and public buildings. Good job. A developer must put a blank approved before building houses in a new subdivision. So a developer must get a what approved before building houses in the new subdivision. Is that A, the PUD, B, affidavit of title, C, plat, D, profit and loss statement? All right, we got C, plat. And you are correct. So when a developer divides land, they must get the government to approve the plat, which is a detailed survey map of subdivision, including where the buildings, driveway, etc. will go. Good job. That was trickier. Alfred and Allie buy a 10-year-old home and have it tested for radon prior to closing. The test results in average reading of 4.8 PCI-L. Under federal law, is the seller required to mitigate the home? A, yes, federal law and state law dictate mitigation. B, no, unless agreed upon in the contract between buyer and seller. C, yes, federal law dictates mitigation over 40 PCI-L. Or D, no mitigation must be performed by the buyer. All right, we got B. Good job. So there is no federal law regarding radon mitigation. The federal government recommends mitigation on houses that test 4.0 or higher. However, the buyer and seller in their contract could agree to whatever guideline they wish. All right, good job, guys. And yeah, in this case, the 10-year-old home was tested for radon, so definitely knowing when what just the tricky thing is in here that says there's no federal law about it, but they recommend it, and then knowing what the max is or higher is going to be definitely beneficial. I also did not know. Oh, good. I'm glad that we redid that because those were good questions. All right, I can probably squeeze in one more. Do you want to do? I guess brokerage relations to agency. We can do leasing of property. Any other suggestions? Here's we do valuation market analysis. Wait. Yeah, this is a good one. So an increase in the value of property, either due to positive improvements in the area or elimination of negative factors, is called A, apportionment, B, assignment, C, appreciation, D, appraisal. So either due to positive improvements. All right, good job. C is correct. The appreciation is increase of value, depreciation, decrease of value. Good job. The term appraisal refers to A, the value of real property fixed by purposes of computing taxes. B, a defeasible opinion or estimate of value of real property as of a certain date. C, the obligation to be personally liable for conditions in a contract. D, an increase in the value of property either due to positive improvements in the area or elimination of negative factors. B is correct. Good job. So anything that says like an opinion or an estimate of value, so opinion of value as real property is on that certain date is going to be related to an appraisal. So you can appraise your house today, and then a month from now, it would appraise for something completely different. So regarding the valuation of property, the term appreciation refers to A, payment of debt in regular periodic installments of principal and interest. B, an increase in the value of property due to positive improvements in the area of elimination of negative factors. B or C, a defensible opinion or estimate value of real property as of a certain date. We know that is the definition of appraisal. Or D, features both tangible and intangible that enhance the desirability of real estate. Well, this was our first question. Oops. All right, good job, guys. Hold on. Sorry, I feel like I'm just copying pasting literally everything. But the more information, the better. A home with a basement wall that is failing is best described as suffering A, incurable function deterioration, B, curable function obsolescence, C, incurable physical deterioration, D, curable economic depreciation. I remember having questions like this on the exam and just kind of going through and eliminating the ones you don't know. Yeah, these are hard. Good job. So it is incurable physical deterioration. So when major structural problems usually cannot be fixed at any cost, that makes economic sense. This is incurable physical deterioration. Curable would be when something like painting would fix the problem. When it comes to like major structural problems, a lot of the time it's an incurable physical deterioration.
That's where I get stuck though, because I feel like you can fix those things.
Yeah, that is definitely a good point. Like you can, but it requires like lots of money or requires a contractor to come in, like even just putting in I-beams or things
Mm,
like that.
yeah.
Definitely like that's exactly like like I said, my first deal had structural problems and we as my buyers actually put in I-beams everywhere and fix the problem. But when it comes to like noting that in the residential property disclosure and things like that, it is the definition of like incurable physical deterioration. But I know it's like that is tricky. It's just like without putting a lot of money into it, then it that makes it incurable. They're kind
Okay.
of stating like what requires doesn't require a lot of work and isn't like a red flag scenario.
Okay.
Yeah. But yeah, that's a good point. I mean, because luckily like my buyers were in construction, so it wasn't a major thing. But if your buyers aren't in construction, it could be a major thing.
Yeah, because I just know, like when my parents were selling their house and they had to get like $20,000 of structural,
Hmm.
it was just like they had flooding in their basement and everything. So that's
Oh
just
no.
kind of like how I viewed it. Like it's curable, but I get,
Right.
yeah.
Yeah. Hmm. Yeah,
Okay.
good point. Exactly. Like it's you like it is curable, but I guess like in their terms, it requires a lot of money that the
Okay.
buyer may or may not have. Yeah, good
Thank
point.
you. Thank you.
Yeah, yeah, sure thing. Yeah, that's a good one because many things don't show up later on in your transactions, but that is definitely an important one because that showed up the very first time for me. All right, so which approach to appraisal is best for apartment buildings? Oh, I remember this one being on too. Is that the estimate approach, cost approach, income approach, or comparison approach? All right, we're saying income approach, and that is correct. Income producing property like apartment buildings gleans the most accurate results from the income approach, either using the capitalization rate or calculating the gross rent multiplier. Yeah, I found it was tricky when you're the difference between the capitalization rate and the gross rent multiplier. Definitely knowing that those are both involved when it comes to the income approach. And that's the best to use for that appraisal is the best to use for apartment buildings. A defensible opinion or estimate of value of real property as of a certain date is known as A, appraisal, B, appreciation, C, market price, D, marketable title. Right, good job. Correct. Cool. So the cost approach is probably most accurate when estimating the value of A, retail shopping center, B, apartment building, C, church, D, single family home. Cost approach, I gotta say C, church is correct. Good job. So the cost approach is the only possible method to estimate the value of a church. Both begin with C, that's kind of how I remembered it. And then the market data approach is the best for a single family home. And then the income approach, which we just went over, is the best for an apartment building or also a retail shopping center. So definitely income approach equals apartment building, retail shopping center. Church equals cost approach and market data equals single family homes. So using the market data approach, how would an appraiser estimate the value of a second bath? Would it be A, visit local plumbing supply houses, B, use a cost manual for reference, C, analyze matched pair sales in the area, or D, find out what the builder of the two houses charge for a second bath, then adjust for inflation? I feel like they were trying to trick you on this. Pick B. Oh wow. So it would be analyze matched pair sales in the area. So what is important is what a buyer would pay for the second bath. Okay, that's a good point. This is determined by analyzing matched pair sales in the area. So analyzing houses in the area that have a second bath and see what they went for would then be a good way to then see how much buyers are willing to pay for sales that recently closed. Yeah, that was a tricky one. I actually didn't even think that through. And that, again, will then help when you do your comparative market analysis to get a listing price for your sellers. Okay, so a method of appraisal based on replacement cost minus depreciation plus land value is known as the A assessment approach, B sales comparison approach, C income approach, or D cost approach. I don't remember. So replacement cost minus depreciation plus land value. All right. C and A. Okay. Okay. See. Okay, so it's actually D. So D is the cost approach. So the income approach is method based on the income producing capabilities of commercial property. The sales comparison approach is based on the recent sales of similar property. The cost approach is a method used by insurance companies. It estimates the value of real estate by figuring the cost of the house or other improvement on the land minus depreciation plus the value of the vacant land. There's no assessment approach, and assessed value is used for tax purposes, not appraised purposes. Well, that was tricky because I also was thinking that. Oh, this was a tough question. So it would be the cost approach because you are looking at, and this is used by insurance companies, and this is when you're looking at what it would cost to build a similar house, then other improvements on the land, and then minus the depreciation plus the value of the vacant land. Yeah, that's a tough one. Next, which is typically used on market value appraisal? Is that A, reproduction costs obtained by estimating the depreciated cost of improvements within similar utility to the subject? B, reproduction costs obtained by estimating the depreciation cost of an exact replica? C, replacement costs obtained by estimating the depreciated cost of the improvements with similar utility to the subject? Or D, replacement costs obtained by estimating the depreciated cost of an exact replica? Wow, I just literally thought they had two of the same questions. Okay, I definitely had something similar to this question right there. All right, so it is C. So it's going to be replacement costs obtained by estimating the depreciated cost of improvements with similar utility to the subject. So what is typically used on market value appraisal? So a replacement using today's materials and method is usually accepted to buyers and would be used as basis of market appraisal. So instead of like ordering completely new piece, they just replace the cost and then obtained by estimating the depreciated cost of the improvement with similar utility to the subject. So similar to the property that you are listing. So the subject is going to be the property that you are wanting to do the comparative market analysis for. Okay, well, good job, guys. Oh, that was a tough study sesh. Thanks so much for hopping on. Appreciate everyone's participation. It's definitely more fun when everyone participates. Even if I get it wrong, at least we all are learning.